Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. My name is Alfonso Gambone, and I am a criminal defense lawyer who practices in courtrooms throughout southeastern Pennsylvania and all of New Jersey. This weekly criminal defense law podcast addresses and discusses some of the most common questions and issues within the area of criminal defense, with a focus on Pennsylvania and New Jersey law. It is based on questions from our clients and their families that we have taken over the years. It is my hope that this law podcast will help you and your family make better decisions during a difficult situation. Our law firm is committed to providing the highest level of professional representation to its clients and educating them and their families about their legal rights under the Constitution. For previous episodes of this podcast, to read my weekly blog or download one of my free criminal defense strategy books, visit gambonelaw.com or call 215-755-9000, 24 hours a day, 7 days a week. Finally, this podcast is made for information purposes only and does not in any way establish an attorney-client relationship. Please enjoy listening. Well, good afternoon. This is episode 3 of the Gambone Law Podcast. This podcast is a weekly podcast in which we discuss criminal defense issues. This week, I will be discussing drug offenses, a very common offense that our law firm defends in Pennsylvania and New Jersey. A drug offense in Pennsylvania and New Jersey can be graded as a felony or misdemeanor offense. And like every week, I will be taking some questions from our clients in this area. So the first question is, what does the prosecution have to establish to convict someone of possession with the intent to deliver or distribute as opposed to just simple possession? Well, this is a very common question. You have to understand, first off, that there's a dramatic difference between these two charges. A possession with the intent to deliver, sometimes called a PWID or PWID, is a felony offense in Pennsylvania, as opposed to simple possession is a misdemeanor offense, and it is much less serious, but still a criminal charge nevertheless. So with regards to possession with intent to deliver or distribute, otherwise known as PWID, the Commonwealth has to establish first possession, obviously, and then the second element would be an intent to distribute or deliver. And they can do this in two different ways. The first way is through observed transactions, and this is where the prosecution would introduce a witness who actually saw a person sell or deliver or give someone else drugs. Normally, this individual is a police officer who is conducting surveillance. And if that was the case, the prosecution would attempt to introduce that evidence through that officer's testimony. And the defense has an opportunity to cross-examine the officer as to their observations and what they actually saw. The second way would be through an expert. You have to understand that most people believe that a PWID charge or a PWID charge can be proven simply when the prosecution introduces a large quantity of drugs. This is simply not correct. The prosecution needs more than simply a lot of drugs. Now, obviously, a lot of drugs goes toward the weight of the prosecution proving its case, but the fact that a large quantity of drugs is found shouldn't really end your defense. The Commonwealth, through its drug expert, has to present other testimony. Normally, this can be done through things such as drug paraphernalia found with the drugs, such as scales, baggies, vacuum sealers, a large quantity of money. All that evidence would present an indicia or an intent to deliver or distribute. We've had plenty of cases where, for instance, a person is found with a large quantity of marijuana, and that large quantity in and of itself isn't enough to establish an intent to distribute as opposed to personal use. So all that's very important in your case, and all that should be discussed with your criminal defense lawyer, and it's one of the first topics that I discuss with all of my clients when they come in the office. If you have an opportunity, I would encourage you to go to my downloadable section on my website, gambonelaw.com, and there you will find a few different strategy books in which this topic is discussed. And I also discuss it in my weekly email, which goes out to all my clients and their families. You can also subscribe to that email by visiting gambonelaw.com or calling our office at 215-755-9000, 24 hours a day, 7 days a week. You can subscribe to our email by phone. Simply tell our office you would like to receive it, and we will send it out to you every week. Second question, can I still be convicted of a drug crime if police don't find the drugs on me, but just in the trunk of a car in which I was the driver? It isn't even my car. Again, this is a common situation. You have to understand that the prosecution or the Commonwealth can establish a drug charge, whether it be possession or possession with intent to deliver, through either actual or constructive possession. They don't need to find the drugs on you, but obviously finding the drugs on a person makes the case a lot simpler. Actual possession, again, is where the drugs are actually found on your person following a search or a stop of some sort. Constructive possession is where the drugs are found in your area of immediate control, and there's proof that you had the ability to exercise dominion and control over those drugs. So taking this example from this question, drugs were found in the trunk. So it isn't your car, so your attorney should look at what other factors the prosecution could attempt to establish that those drugs were in fact yours, or you knew that they were there. The prosecution will typically look at identifying factors such as next to the drugs, what was found. For instance, was it a book bag or your luggage or something identifying you as the owner of that particular item. Normally it's a driver's license or an ID of some sort found next to the actual drugs in a lot of cases, which is a strong piece of evidence for the prosecution. But in this situation where the car isn't yours, the drugs are in the trunk of the car, it's a very arguable point that your attorney can and should make with regards to your actual knowledge. Your attorney, in addition to introducing your own testimony, which you can obviously testify in your own defense, can also point to other circumstances surrounding the stop and the arrest to go toward an argument with regards to your actual knowledge that the drugs were present in the car. All that should be argued at trial. This example also presents another reason why you may want to think about not waiving your preliminary hearing, because at a preliminary hearing, again, I discussed this in a previous podcast and a lot of my articles and my blogs, my newsletters. A preliminary hearing is your opportunity to kind of test the prosecution's case prior to trial. So your attorney can ask questions with regards to actual constructive possession. He can also ask questions with regards to illegal search and seizure. You have to understand that if the DA in the room knows half of what they were doing, and they usually do, they will sometimes object to some of these questions as they are all trial issues or possible motion issues and don't go toward a preliminary hearing. I'm getting off topic right now, but the point is that with regards to a drug case, a preliminary hearing is an opportunity to test all these arguments, especially with regards to actual and constructive possession. Okay, third question. I was stopped for speeding and the police officer told me that he smelled marijuana in the car. I denied it, but he searched the car anyway without a warrant. Was this legal? Well, it depends. You have to understand that in Pennsylvania and New Jersey, warrantless searches are permissible. They're allowed. Police do not need a search warrant to search a car. This wasn't always the law in Pennsylvania, but it recently changed a few years ago with a court case that now allows police to search a car without a warrant. They just need probable cause to search a car. So if police have probable cause to believe that the car contains contraband, they can search it without a warrant. Courts have ruled that the car itself is mobile, and therefore that mobility of the car in and of itself is enough for police to not need a warrant. You also have to understand that a car is much different than a search of a house. With regards to a car search, there is a less of an expectation of privacy in a car than there are in a home. So courts have also reasoned that. With regards to this example, Like a car or a house, you have to understand that it's very important that you never give police consent to search your car, your person, your house. If they want to search the car, don't stop them, but don't give consent. Once you give consent, it waives all of your constitutional rights. So even if your attorney wanted to challenge the legality of that search under the Fourth Amendment to the United States Constitution or Article 1, Section 8 of the Pennsylvania Constitution, it's an upward challenge for your attorney, because they first have to establish that somehow your consent wasn't voluntary or knowing, and that can be difficult. So you don't want to give consent to search that car. If police find drugs in the car, you don't want to make any statements. You aren't obligated to tell police anything. If police stop your car, you provide your license, your insurance, and your registration, and that's it. Don't be a jerk. Don't be impolite, but just provide that information. You are not obligated to tell the officer where you are going, where you've been, or what's happening in your life. If you find something, just don't make any statement. A lot of clients, unfortunately, when police do find something, whether it be drugs or a gun or some type of contraband, believe that if they simply own up to it, it will make the case better for them based on some statement from police. You have to understand that the police officer is doing his job, but he has no power or authority to make a deal with you right then and there, regardless of what he or she says to you. The next question we have here. If police come to my house and ask to search it without a warrant, but I tell them no, can they search it anyway? Again, like the car example, it depends. Normally, unlike a car, police need a warrant to search a house. Like I said before, the expectation of privacy in a home is much greater than in a car. So because of that higher expectation of privacy, there's a higher constitutional protection. So in most situations, police need a warrant to search your home. But again, if police demand to search your house, you don't let them, but they barge through the front door or the back door and search it anyway. Don't get in their way. Let them do whatever they're going to do. Don't make any statements. If you're arrested, you're arrested. Call your attorney. At that time, you can discuss what happened with your lawyer. Don't make statements to police. Don't say anything. Don't try to cut any deals. Again, they don't have the authority to cut a deal with you, regardless of what they tell you. There are exceptions to the search warrant requirement for a home. There's something known as exigent circumstances, but normally that situation is very rare. It's confined to usually hot pursuit of a suspect. So if police are chasing someone into a home, they can go into that home and chase down that person. They don't need a warrant to get into the house. During the course of chasing down that person, if they find something that is contraband, obviously they can take it and they can arrest the person based on that recovery. You also have to understand that when a person runs into a house, and police can and often do a protective sweep to ensure their own safety. Again, they don't need a warrant, but they're obligated to, well, not obligated, but they're permitted to search the car for their own, search the house for their own safety. You have to understand that doing that, though, is much different than a warrant search. They're not permitted to simply open up cabinets, only permitted to search areas where a person could be hiding. Okay, next question. When can police use a drug dog to search a car? Well, a drug dog requires less than probable cause. Police need only reasonable suspicion of the presence of contraband. So there's probable cause to believe that a crime has occurred, which is the standard that police must use to do a search or to arrest someone. And then there's below probable cause, there's reasonable suspicion, which is a lower form of probable cause. You have to understand that police can use a drug dog based on, for instance, the driver's odd responses to questions. For instance, if the driver says, I'm headed to Philadelphia, but traveling in the opposite direction, or the driver's acting extremely nervous, again, not probable cause, but that's reasonable suspicion to use a possible drug dog search for drugs. So again, drug dogs, if they find drugs in your car or your house or your luggage, don't say anything, wait for your lawyer. Final question. If I am convicted of a drug crime, will PennDOT suspend my driver's license? No. In the past, prior to January 23rd, 2019, if you were convicted of any drug crime in Pennsylvania, PennDOT would suspend your license for a first offense for a mandatory 6-month period. That is no longer the case. That has been since repealed. So now if you're convicted of a drug crime, whether it be simple possession or possession intent to deliver, they will not suspend your license, but it's still obviously a conviction if you are convicted. So bear that in mind, obviously. New Jersey, unlike Pennsylvania, it's discretionary. So if you are charged with a drug offense in New Jersey, be aware of that. All right, we have time for one more question. In addition to arguments that your attorney can make at trial, what else can your attorney do to fight your drug crime case? Well, the most powerful argument that your attorney has prior to trial would be a motion to suppress the evidence against you. And this is based on your constitutional rights under the U.S. Constitution, the Fourth Amendment to the United States Constitution, and in Pennsylvania, Article 1, Section 8 of the Pennsylvania Constitution. What it basically says is that you have a right against illegal search and seizure. Now, so again, police need probable cause to search you or your car or your house, and all that falls under those constitutional amendments. So your attorney can make pretrial arguments with regards to illegal search and seizure. And you have to understand that pretrial arguments, it's a different evidentiary standard. Whereas at trial, the burden of proof is guilt beyond a reasonable doubt. At a motion to suppress evidence, it's a preponderance standard. So the Commonwealth doesn't have to establish as much, but the burden is still on the Commonwealth. So with regards to a drug case, if your case is proceeding to trial, in most situations, I advise a client to always look at possible Fourth Amendment issues, because if you're going to trial, there's no obvious negotiations between us and the prosecution, so you lose nothing by arguing a motion to suppress. Even if the motion is not that strong, it still pays to argue it and look at any possible issues. Another advantage of the motion is you kind of get a dry run at all the prosecution's possible witnesses, and also an opportunity to really look at possible trial issues down the road. Also, you get a transcript which you can use at trial if you're attempting to impeach the credibility of a prosecution witness through inconsistent statements. So all those are good opportunities that you can take advantage of a preliminary hearing. If your attorney is successful at a motion to suppress, the court will exclude the evidence against you. In most cases, that will pretty much end the prosecution's case, because without the evidence of the drugs, there is no case. So I would recommend that as a possible way to fight your drug case. So that's all the questions I have this week with regards to drug offenses. Like I said before, if you have an opportunity, go to my website, gambonelaw.com, or call our office, 215-755-9000 if you have more questions. We answer our calls 24 hours a day, 7 days a week. Our website also features all of my downloadable books, my blog, which is updated weekly, and also you have an opportunity to learn more about me and my practice. My name is Alfonso Gambone, and I will see you next week. Thank you.